morning and this afternoon. I will once again review all of them just for grammar, just to make sure all of that is correct, and provide a written printout of the final draft for the parties before we break for the day today. I am also approving of the verdict forms that have been previously submitted to the parties, just noting there's just a few grammatical things that need to be corrected, but the content and substance are there, and I've already addressed on the record any requests by the parties this afternoon.
No, Your Honor, I believe that the final copy that we've been working off of is appropriate.
Any comment about that, Mr. Brooks, or any statement?
I don't consent to being called that name, and I've just told you I don't understand these jury questions. I'm not going to know how are they allowed to pass just because you feel that they should, when I'm telling you I don't understand them.
I would note that
one of those jury instructions came from me, not one. How's that fair?
Mr. Brooks, this court gave you the draft of the jury instructions. I need to mute you because, once again, he's debating about things that I think are very clear on the record. This court provided both the state and Mr. Brooks with a written printout, 107 pages long, of the jury instructions it was considering in this case. We had a discussion this morning. We continued that discussion this afternoon. Prior to breaking for the lunch hour, all of the verdict forms were printed off and provided to both the state and to Mr. Brooks. It is also true that when he was previously represented by counsel, the court had some specific deadlines related to jury instruction proposals, and the state reminded me that there essentially was not an objection raised regarding the proposal and the filing from the state. I had a brief opportunity to look through the record of the inmate communication forms that have been sent during this trial that are on file. I haven't seen anything that references jury instructions. I'm well aware that he has other filings, but I could not find anything related to jury instructions and any specific requests that he is making or made during this case. So for the record, I am approving of the verdicts. I am approving of the jury instructions. And once again, before we break for the day, I will make sure to provide the parties with written printouts of both of the documents as they now stand. Then there are a few other issues we need to go through. Attorney Basie, I think you brought these up prior to the break. Maybe it was Attorney Opper, in terms of scheduling and what I would consider other housekeeping issues, but go ahead and remind me once again of the issues you wanted to bring up. I think it was the alternate sequestration, and there might have been a third.
Yes, Your Honor. The question is to the sequestration of the jurors once they are excused for deliberations, and should the timing require that, an overnight stay or something along those lines. We wanted to discuss that. We wanted to discuss what the court intended to do with the three alternates once they have been selected. It would be our request and position that they should remain in a secure location, separate and apart from anyone else, unless and until full deliberations are complete by the 12 selected to decide the case, so that if needed, and in light of the brief COVID history we have on this record, if needed, one of the alternates could slide into position of one of the 12 who are deliberating if that became necessary. So we wanted to address that, and then we just wanted to address timing generally for closing arguments, verdict returned by the jury, and then the court's intentions as to the rest of the week, should there be guilty verdicts returned.
Sure. Before I address all of those, are there any of those final type of issues, sir, that you would want the court to address? You have been unmuted, so you can answer that. Mr. Brooks, do you have any of those final type of questions or issues that you want the court to address?
She's referring to me.
You are unmuted. I am.
I just told you since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're gonna be based on whatever I'll base them on.
Well, I trust the state will object when appropriate,
Well,
if appropriate.
It's gonna be a whole lot of objection then, because I'm gonna tell the truth. You haven't allowed. You just been making all the decisions for me, even though you know I told you repeatedly that I don't understand, and you still make decisions based on my behalf without my consent, without me. I'm telling you I don't understand, and you still make a decision determining my life.
Are you telling me, sir, that you will refuse to follow the simple rules of decorum, courtesy, civility, the rules of evidence, and
don't try to come
the
with
rules
your
of
slick
procedure?
words. Don't try to come with your slick words, and don't put words in my mouth.
Sir, I am not being slick. I'm trying to
You've
preserve the integrity.
you've been slick. You've
All right.
been slick.
All right. I'm going to mute you, sir, since what you are saying is not productive. It is not courteous. It is disrespectful.
I don't care.
I need to go
I don't
over
care
these.
what you think.
All right, I'm muting him because I need to go over these important issues that have been raised by the state. So as far as the alternates, I do think it is important to keep the alternates who in a secure location, even if that means an overnight, unless and until verdicts are reached in this matter, and I will so instruct the clerk of courts to make those arrangements. We have been doing that all along in any event. As far as selecting the alternates, obviously each of our jurors have a number. I intend to have pieces of equal size pieces of paper made, folded up with each of their numbers, put them in the same turnstile bin that we utilized for the selection of preemptory strikes by lot, and to simply pull out 3 names. Those will be the alternates, and then or I should say not names, the numbers, and then the numbers that are remaining would be those 12 who will deliberate. And so I'll make sure that that's out here for the appropriate time. As I indicated this morning, all of the jurors were provided with some information regarding sequestration. It is the practice of that I've approved in this case that the jurors provide us with certain emergency contact information so that we are able to get a hold of families should there be the need. They're given information regarding sequestration, the purpose of it. If I have not made that a part of the record, I will make sure to get a copy of that filed in this case so that both sides know what was provided to the jurors today before they left. And then I'll also make sure that when the 12 are deliberating, that the 3 who are not are taken to a different jury room with a bailiff, and again, kept in a secure location, but separate from the other 12. In the event one would be needed, we would then take up that issue at that time, but I think it's good practice to have them available if that becomes an issue. As far as timing, I'll first address, I have instructed the jurors to be back at 9 a.m. That's because typically we have a few things to finalize in the morning, so we'll start at 8:30 tomorrow morning. It will also give the parties one final opportunity to read through the many, many pages of jury instructions and verdict forms to just make sure there aren't any other issues that jump off the page or that need to be addressed first thing tomorrow morning. But then I do intend to start with instructing the jury. This case will require a very lengthy time of the court reading off the jury instructions. I do believe it will require me to take some regular breaks, probably every 2 hours, until the jury instructions are read, with perhaps a longer break at the lunch hour. And my best guess is that it'll take between 5 and 6 hours to fully instruct the jury. That's based on the 107 pages. Now, some of those pages, though, are after argument, and so that really kind of begs the question is, will the parties get to their closing arguments tomorrow, or will that be done Wednesday morning? I certainly would like to have the parties make their arguments. Madam Clerk, may I see the instructions that we have thus far? The packet? I just...
It should be done and printed.
Okay, thank you.
The one. Single side.
So the instructions that I read prior to the parties giving their closing arguments finishes on page 73. So given that, I believe that the parties will be able to give their closing arguments tomorrow. It just may be, depending on where that takes us, whether the final instructions are given the following morning, because that's another 30 pages. I'd like to be able to do it. It just really depends on how late of an evening. I'm not opposed to going late, but letting the jurors go to the hotel and then starting their deliberations in the morning if that's what needs to be done.
Understood, and we'll be ready. I think from our recollection, it took you about 2.5 hours to read the preliminary instructions, which was 69 pages in length. So if that holds, I think, we reasonably could do closings in the afternoon, and it'd probably take you about an hour, hour and a half to read those remaining 30 pages. And we may still be able to wrap up by 4 or 5 o'clock in the courtroom.
I think that's a reasonable time frame. Do you have any estimation on the length of your closing? I'm contemplating maybe putting a time restriction for both parties. I mean, we had a solid 15 days of testimony, so I'm mindful that this is not a 30-minute closing.
Well, actually, I'm trying to keep it in the 30 to 45-minute range, just out of courtesy to the jury, Your Honor, and to highlight the important points.
Do you think it would be reasonable to give the parties each an hour total? That would reserve whatever's left from your initial for any rebuttal.
Yes.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying book. I'm looking at the Bible. Thank you. It's not just a book. It's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by it, though? Anyway.
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm not doing it tomorrow.
Then you'll forfeit your right to give one, sir, because as we have.
You can't force me not. What type of court is this where you can say you're gonna force somebody not to be able to give a closing argument? How's that lawful law?
If you choose not to give one,
how's that lawful law?
Sir, if you choose not to give one, you're not letting me finish, and you're mocking me right now, which is incredibly disrespectful once again.
Okay,
you didn't even let me get my sentence out.
You always want to make an incorrect record. Go ahead, make your incorrect record. Go ahead.
I'll mute him once again because clearly he just wants to be disruptive this afternoon. But as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake. We will need a comfort break. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself, and I'll have my clerk make sure we accurately time that. I will read the final instructions, and I'll really leave it in the jury's hands. If they want to start deliberating, that's fine. If it's 7 o'clock at night, I'll probably tell them we're going to break for the night. They'll be sequestered, but they will come back and begin deliberations in the morning. That will be Wednesday morning. But now that I really kind of laid that out and thought about the break I will have for closing arguments with even my 107 pages, we can get this done tomorrow. And so that's my expectation. So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
Then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws they don't agree with.
You are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise. And you can't, so you added these jury instructions at the last minute, then you should have never approved them from the get-go because I never approved them. I told you I didn't understand them at all whatsoever, and you still passed it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear to me you've done your homework.
What you talking about? I don't care what you're talking about. I'm going to let them know that they can nullify any law they don't agree with, which is my right.
It is not your right to do that.
Say that it's not.
It is not your right to raise jury nullification.
Show me lawful law then. Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning. He may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here. and I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented, and those are the bounds. If he's going to, I can only imagine there may be some objections by the state. If there is an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure and the rules of evidence, then he will be in that other courtroom for his closing argument, so that I can exercise mute, frankly, to protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law. You do not have a right to talk about sympathy. That's very clear in the case law, whether it's evidence or arguments. The juries, if you read through the jury instructions, sir, you will see they are specifically told they will not be swayed by sympathy, by prejudice, or passion. They are not to be concerned themselves with any penalties. You can't argue penalties. You can't argue jury nullification. You can't argue legal issues that aren't relevant to the elements and the other law that's in these jury instructions. And those are the very clear rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the jury, or forfeit your right to be present in this courtroom and appear from the other courtroom. And you are squarely put on notice of that here today, sir. With that, I think I've addressed all of the issues the state has asked me to address. Oh, one other issue, verdict timing. I know we have some time on this. I realize that there are many, many victims who may still be watching the proceedings remotely. There may be news media, in fact, that may want to cover the verdicts, and that this jury will take some time due to the sheer volume of counts in this case. When this court is advised that verdicts have been reached, I am contemplating between 30 and 60 minutes before bringing everyone back into the courtroom for the verdicts to be read in open court. And if parties believe I need to wait longer, then let me know. But I think some of it will depend on is it late at night? Is it during the day? Are we dealing with any kind of traffic issues? I realize Mr. Brooks has family in Milwaukee area that may want to be here as well. Even if I consider kind of, the outlying areas of Waukesha, you could be as much as 30 minutes away. So that's my initial thought on that. Any statement from the state on that?
Not on that issue directly, sir. I'm sorry, Your Honor.
It's okay.
I apologize.
Any other issues?
Yes, my other issue as to verdicts was seating, if you intended to maintain the designated benches for the reasons you just said.
I would intend to keep the seating as is.
Okay, with the reserve.
The entire side behind the state for victims.
Okay, and the other side
Public.
reserved for the first 5 minutes, or is that open seating over there? Or do you
My
wanna think
previous, or my rule throughout has been 15 minutes. What I would say is any open seating, we'll open the courtroom. It'll still be open the whole time because we're waiting, right? So it has to be. So any seat that's left open within 15 minutes, victims could also sit on the other side,
Okay,
if that's what you're asking me.
yes.
All right. Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
So, again, I don't understand nothing you just said, but, I don't, how can you deprive me of my constitutional rights? How can you trample on my constitutional rights? How?
Sir, you can forfeit a number of constitutional rights by
Ah.
misconduct on your part.
Not if I reserve my rights, you can't let me reserve my rights and then take them from me.
Sir, I direct your attention to Chambers versus Mississippi,
I'm not
Rock
gonna hear
versus
none of that
Arkansas, State
because-
versus Anthony, Illinois
Did they
versus
reserve their
Allen,
rights? Did they reserve their rights?
the
Did
Beneby
any of those
decision. There's a host
Did
of
they-
case
did they-
law, sir.
Did they reserve their rights?
All right, sir, you are simply mistaken on that. So I'm muting him once again. He's not giving me any other issues to address. We are in recess.
Oh, I'm sorry, I have a few
Go
other.
ahead.
I'm
You
sorry.
do. I'm
Yes.
sorry, go ahead.
I just wanted the record to reflect that at about 2:04 p.m., your clerk had provided the final version of jury instructions to both the state and to the defense. I watched on video as Deputy Wittig left this courtroom, went over to the other courtroom, handed the final jury instructions to Mr. Brooks, and he immediately turned and dropped them to his left off the side of the table. I can't tell from the video if that's where the trash can is located or not, but I did see that immediate response after he was handed the final jury instructions. Another
Did that
thing.
include the verdicts or just the jury
No, just
instructions?
the jury instructions, I'm still doing verdicts.
Okay, it's just the jury instructions, but thank you, because I didn't see that given some of the things I was looking at up here, so I appreciate that.
It's all,
Uh,
the verdicts too.
Were all jurors, or will all jurors then be told to report with an overnight bag?
That's part of the instructions that
Okay,
they were
and you're
given.
gonna make that available to us?
Yes,
Okay.
I'll get Lauren down here right away, and I'll make sure that before Mr. Brooks is taken back to the cell, I see your arms waving, I'll get you in a second, that he's provided with that as well.
All right.
And you as well.
And then one final thing as to timing, and again, I don't mean to be disrespectful to Mr. Brooks or anyone involved in this matter, but should there be any guilty verdicts in this case, would you be intending to proceed to sentencing yet this week or at a future time?
You know, that's an interesting question because I don't know how many victims will want to speak. I would certainly consider that. I mean, I have this entire week set aside yet. And I have Monday morning, but I have some other things Monday afternoon, and then I am not available the rest of next week. So it really just depends on the timing. I would need to know from both the parties whether they anticipate anyone speaking other than the parties themselves. Any family members?
Yes,
I
we-
don't think I need a PSI. This is a trial. This is not like a guilty plea, so. Mr. Brooks, I'll get you. I'm unmuting you. Go ahead. Go ahead. You're unmuted.
And since we're all making records to make me look bad, I think we should state for the record that one of the rights I have is to demand that the court place in the evidence any unrevealed contract, statute, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to, sir?
I'm referring to my rights under the Sixth Amendment.
And what
My
case law
constitutional
says
right
you have a
under the-
right to do exactly what you just said you have a right to do?
The Constitution, Amendment 6.
Sir, that is very general, your statement. It's vague. There's nothing
So we gonna go
specific
what?
you have
What
referenced.
You want paragraph 2 or something like that? Is that what you want?
No, that's not what I'm saying, sir. You're making
So,
general arguments
also-
that aren't based in fact. and our overgeneralizations of what the law requires as well.
I accept for value and return for value any documents in this matter. Since, you know, it might be another record of what I'm doing, you know, since it's always a record of what I'm doing. And I also have the right to ask, is this common law or admiralty law? Because judging by the gold eagle on top of the flag, it's some explaining that needs to be done. And that is a military symbol. So is this a common law court or admiralty law court?
Mr. Brooks, I'm frankly not going to address these nonsense legal theories of yours. I'm muting you. They have been debunked. They are typical sovereign tactics that have no place in our judicial system. We are in recess. I'll see everyone tomorrow morning at 8:30. I'll just direct the bailiffs to wait until we have the verdict forms to give. And if it takes us longer than 30 minutes, we'll make sure they're delivered to him in his jail today. Thank you, everyone.
Thank you.
I'm on 42,